What's up everyone, it's the Law School Lumberjack. I hope you're having a wonderful day and a happy new year to all of you. Today we're going to be doing another installment of our Corporations Law / Business Organizations Law 101 series. And today we will be looking at piercing the corporate veil. Now this will be a relatively short video because piercing the corporate veil is not dealt with in great detail in most corporations law courses in law school. However, it is an important topic that is nevertheless covered in your courses. Now, in our previous video, we talked about how a corporation was a separate legal entity from its shareholders. So, among other things, what the corporation does for shareholders is it insulates the shareholders from liability through its position as a separate legal entity. Now, this is a very powerful vehicle for shareholders because it allows shareholders to invest in businesses while availing themselves of what's called limited liability, or in essence, capping their liability at what they invest in the company. Now, on the other hand, this benefit can be used in a way which is against the public policy and is used essentially to take advantage of the system and allow a person to use the corporation for their own bidding while availing themselves of limited liability. So as a result, in limited circumstances, the court will what's called pierce the corporate veil, or in other words, have the principal or shareholder of the firm be personally liable for the debts and liabilities of a corporation. Now, as I'm sure you're aware, the threshold to do this is very, very high. Because of this long-standing view of the insulation from liability and the separate legal entity, courts are generally fairly loath to pierce the corporate veil. However, they will do so when the corporation is incorporated for an illegal, immoral, or improper purpose, and or when the corporation or its creation is tantamount to fraud. And how this kind of manifests itself generally, and how the courts views this, is whether or not the corporation is essentially a mere agent of the principal or shareholder. So if the principals and shareholders are essentially acting like puppet masters, having the corporation do their bidding, it then becomes possible, not necessarily likely, but possible, that the court will pierce the corporate veil. So one example of this where the courts have held that a company is in fact a mere agent of another company is in the case of Salaberry Realty and the Minister of National Revenue. In this case, I'll just give a brief run through of the facts. Essentially, there is a parent company and what essentially amounts to kind of a pyramid of subsidiary companies owned by the parent. Now, at the bottom rung, each of the lower subsidiary companies own 1 to 2 properties each. These properties are then sold and tax is accrued. However, the Minister of National Revenue takes the position that because of the kind of pyramid-like nature of this, of the affiliates, the parent company should be taxed rather than the individual quote-unquote shell companies. So this gets brought to the Federal Court of Appeal. In short, what the court does is they look at the pyramid-like nature and the fact that there is very little separation between the parent company and the subsidiary companies to hold that, in fact, the subsidiary companies are essentially a mere agent of the Salaberry Realty Company. As a result, the court pierces the corporate veil and allows the Minister of National Revenue to tax the parent company rather than the subsidiary companies. So some of the questions the court will ask is, 1, does the parent company essentially have true direction and control over the subsidiary companies? Secondly, the court will look at whether the profits of the subsidiary company are separate from the profits of the parent company. In the Salaberry case, one of the things that weighed against the Salaberrys protecting the corporate veil is that the profits basically trickled upwards to the parent company, which suggested that there wasn't true separation. And one of the other considerations is whether or not the will of the parent company is encroaching on the corporate personality of the subsidiary company, such that the subsidiary company essentially has no agency and is acting essentially as a puppet of the parent company. The Salaberry case is just one example where the corporate veil was pierced. From other case law, the court has set out numerous other factors that can be considered to determine whether or not the veil of a corporation should be pierced. For example, in the family law context, in cases such as Lynch and Siegel, the courts have looked to whether it's in the interest of justice to pierce the corporate veil in order to protect family members who may be entitled to spousal or child support. So this may be obvious, but just for the sake of clarity, you might be wondering what happens if the corporate veil is pierced. So Normally, as I said, a shareholder in a company avails themselves of limited liability such that they only face the risk of losing their initial investment in the company. So if a shareholder puts in $1,000 in the company, that investment is what their risk is that they're going to lose. Should the company then go bankrupt, for example, the shareholder may not get nothing from the company, but they don't owe anything to creditors. Now, if the company's veil is pierced for whatever reason, the creditors, the people who are owed money, people who have faced liability as a result of the company, can then go after the shareholder personally. Again, this is just meant to be a brief primer on the subject because most business organization courses don't go into this subject in great detail. In any event, I hope this video was helpful. If it is, I'd really appreciate it if you could like and subscribe. Thank you very much. Take care. See you next time.